Construction projects do not always go as planned. Whether the issue involves unfinished work, alleged defects, delays, or disagreements about quality, disputes between homeowners and contractors can arise even when both parties begin the project with the best of intentions. When problems occur, many homeowners assume their next step is to file a lawsuit. However, Georgia law requires an important process to take place before litigation can move forward. Under Georgia's Resolution of Construction Defects Act, RCDA, commonly referred to as the Right to Repair Act, homeowners must provide contractors with notice of alleged construction defects and an opportunity to inspect and potentially resolve the issues before filing suit. The law is designed to encourage communication, promote voluntary repairs, and potentially avoid costly litigation. Understanding the requirements of the RCDA is essential for homeowners seeking to protect their rights. Failure to follow the Act's procedures can result in a lawsuit being delayed until compliance is achieved. At the same time, homeowners should be aware that complying with the RCDA does not automatically extend or pause applicable statutes of limitation, making timely action especially important. Compliance with the RCDA may be tedious and time-consuming, but it is not difficult. The statute provides as follows. RCDA Section A, C, the homeowner must provide the contractor with written notice of the claimed defects with sufficient detail and documentation to identify the problems. Such notice must be provided at least 90 days before filing suit. But if the contractor does not respond within 30 days or responds but denies the claim with no offer to pay or make repairs, then the homeowner will be deemed to have complied with the RCDA and may then file suit immediately. RCDA Section D. If the contractor responds to the homeowner's initial notice with an offer to pay or repair, if the homeowner intends to reject that offer, then they must do so in writing, with an explanation of the rejection. The homeowner will then be deemed to have complied with the RCDA and may then file suit immediately. Note, however, that if the contractor's offer is later deemed reasonable, then the homeowner's recovery may be limited. RCDA Section E. If the contractor responds to the homeowner's initial notice with a demand for inspection, the homeowner is required to provide prompt and reasonable access for the contractor to inspect, which the contractor is to complete within 30 days if possible. RCDA Section F, I. Within 14 days after the contractor's inspection, the contractor is required to make a written offer to pay, repair, or both, or else confirm in writing that they will proceed no further to remedy the dispute, with an explanation as to why. The homeowner may reject the contractor's offer, but must do so in writing, with an explanation of the rejection, within 30 days, or else will be deemed to have accepted it. Once again, if the contractor's offer is later deemed reasonable, then the homeowner's recovery may be limited. If the contractor does not timely make an offer, then the homeowner will be deemed to have complied with the RCDA and may then file suit immediately. RCDA Section J, K. Just because the homeowner rejects the contractor's offer doesn't mean we're all done with the RCDA. The contractor has an opportunity to make a supplemental offer, which must be made within 15 days after the homeowner rejects the previous offer. Curiously, the statute does not require this offer to be made in writing, but if the homeowner wishes to reject the supplemental offer, the rejection must once again be in writing, with an explanation of the rejection, within 30 days, or else will be deemed to have accepted it. As before, if the contractor's supplemental offer is later deemed reasonable, then the homeowner's recovery may be limited. Or if the contractor's offer was for payment of money, then the homeowner's recovery will be limited to that amount. In addition, the homeowner will not be entitled to recovery of attorney's fees. The RCDA provides that whether an offer is reasonable will be determined by the trier of fact. Finally, it should be noted that the RCDA Section P does provide that the homeowner and the contractor may make a written mutual agreement to deviate from the process established by the Act at any time after the homeowner makes the first demand. However, as a practical matter, the RCDA favors contractors so heavily that there is little or no incentive to agree to a different procedure. The most likely scenario where a contractor might be convinced to a more streamlined procedure, or possibly arbitration, might be where the cost or value of the repairs is relatively low. Every person in this country has a constitutional right to represent themselves in any and all phases of a legal or quasi-legal proceeding, and navigating a homeowner-contractor dispute under the RCDA is no exception. However, serious legal rights are implicated in the RCDA, and there are traps for the unwary, particularly as relates to timing issues. We recommend that you engage qualified legal counsel to assist with such a claim at the earliest opportunity. This video is for educational and informational purposes only and does not constitute legal advice. Viewing this content does not create an attorney-client relationship. Laws vary by jurisdiction and change over time. Additionally, the information presented in this video relates primarily to Georgia law and may not apply in other states or jurisdictions. Consult a qualified attorney regarding your specific legal situation before taking any action based on the information presented.